channel. Find out how you can support our mission at the links in the description below.
Welcome, everybody. We are live back in the studio in Allentown, which I thought you might enjoy that. That I flew all the way back to Allentown for you, so we could do a show there. Haha, I've tricked you. No, it's a green screen. Haha. Anyway. So welcome back to our comfy studio in Allentown with our, it's over there, the YouTube, our little YouTube award for 100,000 subscribers. Soon to be a diamond award, right? And then we'll have we're going to get 1 million then sometime soon, right? It's Game of Thrones up in here. Yeah, that's really what's happening. We have a really cool story today that I thought I would go over. We have sort of so you guys like sovereign citizens. We like to talk about sovereign citizens and how they sort of misunderstand the law. This has an air of sovereign citizenness to it, and I thought this would be a really fun story to go over, some kind of trial by combat, but in a divorce. There's a lot to unpack here, so we might be here for a while. So I'm just gonna get right into it with the matter of David Zachary, which is how my brain put those things together. The matter of David Zachary Ostrom, petitioner, and concerning Bridget Marie Ostrom. These are our parties who are, I believe, already divorced. So this is some kind of petition for writ of quo warranto, according to 28 USC 1651. Now, I have prepared a little bit on what those things are, but we can also just sort of read what this is. Demand for proof of authority or jurisdiction to deprive property without due process, which is weird, and they demand to vacate, and they demand judicial review. Okay, this is already an ongoing matter in a court, so I'm not sure how due process comes into it, because due process is where you have notice and an opportunity to respond. And he's in a court already, and he's already divorced, so how is there no notice and an opportunity to respond? But okay, let's just continue here. And he's asking for, well, why don't we just go over this real quick, where he's asking for a writ. What is a writ? A writ is like an injunction. So if we go over here to define writ, what is a writ? A form of written command in the name of a court or other legal authority, which we don't really have to worry about that. So we're not asking for a writ from a sheriff or something. We're asking for an order from a court to act or abstain from acting in a particular way. That is very much an injunction. So we would just call it an injunction now, but okay, he's calling it a writ. One of the writs we still use today is like the writ of habeas corpus, produce the body, produce the injured party, basically, is what it means. And so if we then translate that, the writ of quo warranto is by what warrant or by what jurisdiction. So asking the court to prove that they have jurisdiction. Again, a little sob city, a little free man of the land, a little natural person-y, because we're already in a court. They're already getting divorced. So how is it that they're going to ask the court to prove jurisdiction? Maybe they'll say so. And then he's going to cite this 28 USC 1651, which just says that courts can issue writs, or rather injunctions. So, oh well. Big deal there. Let's get straight to the juicy bits. Hello, everyone. I see all of you in chat. Very nice to have all of you here. So here we are. Comes now, petitioner David Ostrom demanding to vacate and void judgments alleging to be court orders, allegedly, for support and custody that are illegally being used to deprive this natural man of his natural rights to, he's starting in already, to ownership of his property and relationship of his children. Petitioner demands judicial review regarding court's denial of petitioner's capital's fundamental parental rights and denial of equal protection under the law as guaranteed by the 10th Amendment to the Constitution. Equal protection is not the 10th Amendment. What is a 10th Amendment? I forget what the 10th Amendment is. Hang on. We're going to look this one up. 10th Amendment. The federal government has limited powers only to be granted by the Constitution. The amendment states, but a truism, that all is retained that has not been granted. Okay, so that's like the separation of the federal government and the state government. Okay, but wait a second here. We're in an Iowa court. In the Iowa District Court for Shelby County. So that's not a federal court. So that shouldn't really invoke the 10th Amendment now, should it? Anyway, I'm not going to try to make any sense of that. Let's continue and get to the juicy bits, like I said. A writ of quo warranto under all writs section of 28 U.S.C. 1651 is demanding evidence of authority to hold proceedings concluding in the deprivation of property without the 7th Amendment guarantee to trial by jury. I believe trial by jury is reserved for criminal, like the guarantee to a trial by jury is for criminal offenses. And I think states can still set their rules for what trial by jury, or what the regulations are for which matters can be held in front of a jury. But we don't typically do divorces in front of juries. At least not that I remember ever doing a divorce. All of my divorce matters and custody matters went before special masters, and if you didn't agree with the special master, you could appeal to the actual sitting judge. And I do remember having many custody matters that got before, well, not maybe many matters, but many hearings that got before the chief judge of Northampton County at the time. So he says, the Supreme Court and all courts established by act of Congress may issue all writs necessary or appropriate to aid in their respective jurisdictions. An alternative writ or rule nisi may be issued by a judge or court which has jurisdiction. Okay, where's your proof? Where's your argument? Due process of law is equivalent with law of the land. No, due process of law is your right to a fair process, including notice and opportunity to respond and a meaningful court hearing with reasoned adjudication. And he says that that's law of the land. Okay, it's not the same. I don't know what he means by law of the land. And any actions taken in violation, I guess, of due process or law of the land, I don't know which one, but they're equivalent, so in his mind they're the same, are null and void. Ab initio. I don't remember what ab initio is. Jeez. These guys really like to make me look things up. Ab initio is a Latin term that means from the beginning. Okay. A natural man. David Ostrom contends that his right to due process, a constitutional guarantee, was deprived, and the United States Supreme Court has held that judgments and orders made without due process of law are void and can be attacked. Okay. This court must provide evidence of jurisdiction to order support. Okay, here we go. Support is either spousal support or child support. The court must provide evidence of jurisdiction to order support as guaranteed by the 4th, 5th, 6th, 7th, and 9th, and 14th Amendments. Some of those are actually apply. So your 5th Amendment is your right of due process. Your 14th Amendment, I think, is your Equal Protection Amendment, which is incorporated by the 5th Amendment against the states and the federal government, if I recall correctly. Where there is absence of proof of jurisdiction, all administrative and judicial proceedings are a nullity and confer no right, offer no protection, and afford no jurisdiction. Aren't these people already divorced? Like, in this court? Like, the guy subjected himself to the jurisdiction. Like, you make these arguments in the beginning. For example, there's very few rights that aren't waived if you go through a court proceeding and you don't object to certain things. You usually end up waiving those rights. The only one I can think of is subject matter jurisdiction, which says the court doesn't have jurisdiction over the subject. Like, for example, if you tried to file a copyright claim in state court, you could argue subject matter jurisdiction at any time, I think. It's been a while since I actually had to do that, so I don't think I've ever had to argue subject matter jurisdiction. Actually, no, that's not true. We've recently argued subject matter jurisdiction through another attorney for the Strike 3 Holdings matters in Florida court, where they are filing copyright cases in Florida court as a discovery action just to get defendants' names. But that's a whole other video. The burden of proving jurisdiction rests upon the party asserting it. Asserting jurisdiction? Okay, and he doesn't cite anything there. The law provides that once state and federal jurisdiction has been challenged, it must be proven. Okay. The alleged public officers in this action are required by a subscription under general law to support and defend the Constitution of the United States and Iowa constitutions. Again, no cite. Under the 14th Amendment, there can be no state laws that deprive guarantees in the Bill of Rights, such as the 7th Amendment guarantee to trial by jury, to prevent denials without clarification of evidence by an alleged judicial actor whose salary is partially or wholly paid by federal funds. What is he talking about? I don't even know if the 7th Amendment applies to the states, but let's assume that it does. Again, that's only for criminal matters. The 4th Amendment protects a natural man's property from seizure unless by way of a warrant accompanied by oath or affirmation. That's also a misstatement. The 4th Amendment prevents the seizure of property, the search and seizure without a warrant, as in the police can't come and seize your property without a warrant that has been adjudicated by a judge. And so he says, here we're finally getting to it, Child Support Recovery Unit did not properly have a warrant issued for wage garnishment. So he's upset that he has to pay child support. Now, I have practiced family law before, and let me tell you, they don't have any time for this. They don't give this kind of argument any weight. The fact and law behind child support is fairly well established, and sure, you should hire a family attorney in the state that you're having an adjudication to tell you what the child support laws are, but I guarantee you they have the right to garnish wages. I have even had them pursue people across state lines. I have had them pursue people across state lines for rather large amounts of money. If you don't pay your child support, well, it's not like they just put child support on hold, and then when you finally resume your child support, you just pick up, with the same payment. No, you owe all that money. So you could have a large bill by the end of it. The Constitution of Iowa, Article 3, Section 1 states, the powers of the government of Iowa shall be divided into legislative, executive, and judicial branches, and no person charged with the exercise of powers properly belonging to one of those departments shall exercise any function appertaining to either of the others, except in cases... Okay, so that's the separation of powers. That has almost nothing to do with this. I don't see a separation of powers argument here. The Child Support Recovery Unit is within the executive branch. They have no authority whatsoever to create a warrant. A warrant must come from a judge and must be signed. Yeah, he's wrong. The Child Support Recovery Unit could very well be an agency established under the executive branch, but what do you think executive means? I mean, I hope it picks back up where I left off. I think it'll pick back up where I left off.
Oh, crap.
Yeah, check it out, Brandon.
Hello?
The Child Support Recovery Unit is in the executive branch. And the executive branch, what do you think an executive does? They execute the laws. So if a judge issues something to an agency, they can definitely execute it. Did we pick back up, Brandon?
Yeah, we're good.
Okay, good. I figured that my stupid mistake would be correctable by YouTube this one time. I should maybe move that to a different screen, that button. This court and the child support unit are denying the petitioner his inherent natural rights. The court cannot have concurrent jurisdiction with the Constitution. What? The court cannot have concurrent the Constitution doesn't have or not have jurisdiction. The Constitution is the Constitution. That's like the bylaws for the country. The petitioner is refusing to acquiesce and demands showing of jurisdiction. Petitioner demands oath of office be provided with a bond for a judge. I have no idea. This is definitely sovereign cit stuff. Somebody has been on the wrong websites and wasted a lot of people's time.
Perusing the wrong articles.
Yes. And so now then they call it fraud. Enforcement agency misrepresentation of law is fraud. Support order does not even follow the state guidelines regarding wages earned. Okay, there you go. That's an actual argument. If the agency does not follow the support guidelines, yeah, you can appeal and you can make that argument. Okay, so what we want to look for next, though, are the details of his argument. What are the guidelines that are violated? How are they violated? How does the law apply? What's the right number? Where's the right number? Nothing. I don't see anything. Petitioner.
I love how excited you were that you found an actual argument.
Yeah. Finally, in the second page, argument 19 or point 19 is an actual legal argument. The petitioner contends that the state of Iowa district courts are infringing upon its fundamental rights. Yeah, you said that already, dummy. U.S. Supreme Court regards parental rights as fundamental. Such status should subject any legal procedure. Do you see what these people do? Do you see what sovereign citizens do? Like, can you imagine the judge having to waste their time reading this, and they're like, I have to try and make sense of this, and you've seemed to have done it on purpose. Like, you seem to have written gobbledygook on purpose to try and waste my time. And let's see how much you think the guy is wasting the judge's time from here on out. This routine and cavalier deprivation of parental rights. Parental rights to what? Not pay child support? That's not how that works. Takes place in the context of a divorce where, during the pendency of litigation, one parent is routinely deprived of significant parental rights without any demonstration that a state interest exists. What? Much less that there is a compelling state interest. Let me tell you what the state interest is, because I know this one. This one applies to all 50 states. They phrase it in different ways, but they all say that the state's interest is the best interests of the child. And trust me, you can go look it up all you want. You can go hire attorneys all you want. That is a real thing. And the state has a very compelling interest in ensuring that custody arrangements operate in the best interests of the child. It's actually a great standard, and I didn't have any problem practicing custody law to that standard. I got out of family law for lots of other reasons that we're going to talk about. In marked contrast to our current practice, treating parental rights as fundamental rights requires a presumption of joint legal and physical custody upon divorce. I don't know how much he understands the presumption. So the courts do presume that joint legal and physical custody is in the best interest of the child until they learn more. If there was somehow nothing more, yes, that would be the presumption. But no court that I've ever been part of or ever heard of has ever stopped the inquiry at this presumption. And I think it sounds like he wants... So I'm guessing, before I even know, it sounds like he did not get the custody arrangement that he wanted. And because he did not get the custody arrangement that he wanted, he had to pay child support more than he thought he should. So imagine for a moment that it's, instead of a 50-50 custody arrangement, it's a 60-40 or 75-25 in favor of the mother. And we don't know why. I'm not saying that he deserved it or she deserved it, although his pleading here is not convincing me that he didn't deserve it. That's just my suspicion, not my conclusion. If he goes around acting like this in public, trying to just tick people off and waste people's time, well, maybe that's not the worst violation in the world, but it's certainly something to argue against the best interests of the child being with the father more. But I'm going to assume that mom got more custody, and because of that, because she has more custody, she gets more child support. Now, I know there's some controversy around child support. Sometimes people use child support for themselves instead of for the child, and that's terrible. But child support does get divided up among the parties according to how much visitation they have. And the law, for example, uses many factors. In Pennsylvania, I believe there's 17 factors that we use to determine what the child support obligations are. And there's a whole calculation they have to do. And you go before literally a child support officer who just calculates your child support. And then if you have a problem with it, you have to take it up with the special master. And if you still have a problem with it, you have to petition the judge. See, now we're getting going. This presumption may be overcome by clear and convincing evidence, such as an arrangement that is harmful to the children. Okay, but yes, you present evidence, and so they probably didn't just grant custody arrangements without having conducted some kind of evidentiary hearing. Usually, there's some kind of mediation that's held before this hearing, so that the parties can attempt to work out a quote-unquote voluntary arrangement. It's a little bit compelled. It's encouraged by the mediator. And there are mediators out there who have a very high success rate of accomplishing a private custody arrangement at the encouragement of the mediator. And if that feels wrong, you certainly could have a mediator that is not behaving properly or something, but on its face, I have not found the mediators to be improper. They usually listen to both parties and hear the arguments of the attorneys and take things seriously. These courts have created two unequal classes of parent, the primary custodial parent and the visitor. Okay, so he didn't have custody, he had visitation. That's different. So he probably had joint legal custody, which means they can both make decisions medically and legally and stuff for the child. They have to talk to each other and make those decisions together, even though they're divorced. And then the mother probably had primary physical custody, and he was probably the visitor. Tack is going to tell me at some point here how right I am, but not yet. This directly infringes upon petitioner's 10th Amendment right to, I think it was the separation of federal and state governments. That's not what we're talking about here. The right to create two unequal classes of people has not been specifically granted to the state courts of Iowa. Okay, so I see his argument. He's saying that the creation of unequal classes of people is a constitutional thing that needs to be governed by federal law instead of state law. That's not an argument. That doesn't mean anything. That's gobbledygook. There is no evidence that the petitioner is not supporting his children. That's not what that is. The standard is best interests of the child, not did he pay his child support, and if he pays his child support, he automatically gets joint physical custody or equal physical custody. Now, again, this has nothing to do, it's not the presumption. The presumption he's talking about is right. Yes, the father should have equal time as the mother. And that's not what we're talking about here. They've already had the hearing. So there's been an evidentiary hearing of some kind or a private custody arrangement. I'm assuming it was a hearing because he wouldn't really have any leg to stand on if he made a private custody agreement. That's an agreement. That's not a court thing. It's the duty of the courts to be watchful against stealthy encroachments. That's not a thing. I mean, it's probably, if it is the duty of the courts to adjudicate. The petitioner contends that the support and custody orders are illegal and demands the court and its officers show that they have authority and jurisdiction which they don't really have to do that. And you'll see what the judge says. So then this is another filing of his. So that first filing was when? The 2nd day of January. This second filing is the 2nd day of January. Comes now petitioner David Ostrom in support of his motion. So this is... okay, so this is what he's demanding. He's demanding these things. But this is his supporting affidavit. And we have a very excited dog outside. Petitioner objects to his income being imputed by the court. Okay, this is making a whole lot more sense. And notice that we would have learned all of this very quickly if this had been prepared by an attorney. What is imputed income? Well, when you don't participate in the child support process, they will assume you can make an amount of money. If you don't provide the evidence that's required for your child support calculation, they will look at what kind of job you have or what kind of skills you have. They might even ask your former spouse or the mother or father of your children who is appearing. They'll ask them, what did you do or what kind of skills do you have? And they'll take that and impute income to you. They will assume that you can make a certain amount of money. This does have this is a tough situation for people who didn't respond, which is their problem. But if they don't respond and they get income imputed, or if for some other reason they get income imputed to them and they don't make that income, you could find yourself owing hundreds of dollars or more in child support when you don't make that much money. But there are also people out there who will intentionally take a much lower paying job just to screw their ex-spouse out of child support, which that's a really horrible situation because the support is for the child, so you're taking money away from the child. Yeah, I'm not going to go any further into the politics of that, but that's what happens. Petitioner objects to the primary custody award to respondent. Called it under 10th Amendment equal protection and violation of his natural rights without good cause and compelling evidence as required by the Constitution. With the fact that they imputed income tells me that they might have held a hearing. Petitioner objects to the violation with this two unequal classes of people. That's not what that means. It means that your equal protection means that everybody is due the equal protection of the laws. That doesn't mean that there can't be, a criminal getting sent to prison is not an unequal class of person or something. That's not what that means. If you commit a crime and you get convicted, equal protection of the laws means that you had the same rights under the law as everybody else does. Everybody who commits murder is subject to prosecution and prison. If somebody is subject to some over prosecution, and I really haven't seen the argument for under prosecution yet, but if somebody is subject to over prosecution, maybe there's an equal protection argument there. Or if someone is subject to prosecution because of their race or sex or sexual orientation or something, that person might have an equal protection violation. There's nothing in here that says that it's happening to him because of his gender or age or culture or ethnicity. Rather, they're saying they imputed income to him, which I'm saying would be before or because, sorry, the dog's distracting, because he didn't participate in a hearing. Now, if I find out during the course of this that he did participate in the hearing and they ignored his evidence or something, well, we would need to look at the evidence. Imputing petitioner's income is in effect... Oh, wait, we skipped one. Judge Gukin. I already love the name. Can we just take a moment to pay our respects to Judge Gukin?
Judge Gukin.
I am sorry that Judge Gukin had to whatever bullying and and name calling he or she suffered in grade school. I'm very sorry. specifically states that the petitioner moved to Harlan, Iowa. Petitioner would be our friend, the father, right? David Ostrom. David Zachary Ostrom. Okay. So, Gookin specifically states that petitioner moved to Harlan, Iowa, leaving behind his job in Oskaloosa in an effort to be closer to his children. Judge Gookin further states no one can fault the petitioner for this. Okay. So then they imputed the petitioner's income, in effect, faulting the petitioner for moving to be closer to his children. These two things are incongruent. Okay, this is very close to an actual argument. Why are we on the fourth page of the documents so far before he gets to the actual argument? Petitioner objects to Judge Hooper's ruling that a change in circumstances has not taken place. Well, okay, we're getting really deep into family law, guys. What do we need a change of circumstances for? We need a change in circumstances in order to alter a custody arrangement. So if you make, this is very important, if you have children and you're going to have to enter a custody arrangement at some point, you don't want to get into a custody arrangement just to get out of it's just easy, I'll just sign anything and then I'll just change it later. No, you can't change it unless you can also show a change in circumstances. Usually changing a job or something is a change in circumstances. Most times a court doesn't give you a hard time about allowing you to reopen a custody matter for even a small change in circumstances, but it must be a recognized change in circumstances. You can't make something up, and maybe there's more to this here. Let's take a look. A change has taken place. Income is lowered by 18%, and Judge Gookin notes the petitioner cannot be faulted for moving to be close to his children. Okay, that's the best argument I've seen so far. That, yeah, if I was his attorney, I might use that. I don't know why I can't highlight this. I might use that to as an example of a change in circumstances, and I might be a little appalled if the judge said, no, that's not a change in circumstances. Maybe there's an appealable issue on that. He needs an attorney, because what he's doing here is going to piss off the judge, and you'll see what happens. Petitioner objects to contractual obligations of child support. Petitioner is by birth a state citizen of California and a resident of Kansas. Petitioner does not support his children, or petitioner does, excuse me, let me correct that. Petitioner does support his children and demands evidence that he doesn't. Petitioner objects to CSRU, the Child Support Recovery Unit, filing income withholding against his employer. Such withholdings must be made via a warrant. Iowa has no jurisdiction. Well, that's not true. What happens in these cases is Iowa does all of this and then sends a signed legal or court documents, effectively like a warrant, to the foreign state, and then those states have agreed to work with each other about child support issues, because this is a very common problem. So although Iowa may directly have no jurisdiction, they do send things to his state, which I'm assuming is Kansas, and then that the state of Kansas then will attempt to collect it from him by garnishing his wages, it looks like. Petitioner objects to the contractual agreement. It's not a contract. Unless he has privately agreed to a custody arrangement, that's a sort of contract. Petitioner objects to the court's assumption that petitioner left his job in Oskaloosa willingly. Oh, that's another tough one. He did leave it willingly, but he left it willingly to be closer to his children. But the other thing I'm concerned about is he said he has a residence in Kansas, but I thought he said Harlan, Iowa. He moved from Oskaloosa to Harlan. Tack, what am I missing here?
He moved to Harlan.
So he did move to Harlan. He doesn't live in Kansas anymore?
He's not in Kansas anymore.
He's not in Kansas. Why? Why is he saying he's in Kansas?
Jesus Christ.
By birth is a citizen of California. I've never heard, there's no citizenship for states. The citizenship is for the country. So you have United States citizenship. You can have a residence in a state, usually by moving to that state and staying there for at least 6. Well, you could have a residence any place, but within 6 months of moving there, you're supposed to change your driver's license and all that. So, yeah, he could change his residence, but it seems like he moved from Oskaloosa to Harlan, not to Kansas.
He might actually be in Kansas. I'm checking the unredacted
Okay.
filings, and it lists a Kansas address.
Okay, so I'm trying to piece this together because he's not really forthcoming with this, is he? Normally, you would tell your story of how did we get here. So if he moved from Oskaloosa to Harlan and then to Kansas, yeah, that would sort of be a change in circumstances, but I would also expect that to require a change in circumstances and a new custody arrangement because there's just not going to be a way for him to visit his kids as much. Sometimes we see this as the kids live with the one parent in one state but have regular holidays with the parent in the other state. Sometimes it's like a 2 or 3 week holiday in the summer or something, maybe even more. So
Now,
go ahead.
really quick, isn't it a typical like sovereign citizen argument to say that you're a citizen of a state?
Yeah. This really smacks of sovereign citizen crap. Iowa has no personal jurisdiction, for example. Petitioner objects to contractual arrangements. Petitioner objects to order regarding dismissal, where Judge Hooper assumes that Ostrom's decrease. My monitor just went out. There we go. That Ostrom's decrease in income is self-inflicted. Once again, Judge Gookin states Mr. Ostrom cannot be faulted for moving closer to be near his children. So we have a disagreement between 2 judges. Petitioner objects to the court's ruling and failure to enforce the court order allowing petitioner telephone and electronic contact. What? Okay, now that's... If there's a court order that allows petitioner telephone and electronic contact, then I'm not sure why they would fail to enforce that. Unless, of course, he wrote to the judge like this, and then the judge may have just not had any respect for his filing because the judge had to do what I'm doing and take 23 minutes so far. We're into this. No, we're more into this. We're like 38 minutes into this because I accidentally pressed the stream button and it probably started over. And my monitor keeps going out. That's not fun. That's probably a crappy cable. Not sure why it would do that. Further, due to the court's inaction, the respondent has now spent over a year alienating the parties' minor children from the petitioner. Yeah, that's terrible. And then something about the party's daughter, which we have redacted because, you never know. Daughter's going to grow up and someday, she's going to come across this video that the stupid lawyer did in Pennsylvania with a stupid green screen. And she's going to be like, why is he talking about my childhood? So we're not going to do that. We're going to respect that. Petitioner generally objects to this court exercising powers not specifically granted to it. Yeah. We got all that. All right. We're getting to the juicy part, I swear. So now he has an objection for the violation of fundamental rights. This is also January 2nd. Wow, he really put this all together, huh? If you're going to take the time to put this all together, you could have put the time into, earning more money for your children, or maybe hiring a lawyer, or maybe just putting together an actual legal argument. Just saying. Petitioner objects to opposing counsel. Okay, so wait. He doesn't have a lawyer. She does. Petitioner objects to opposing counsel, furthering discord between the parties. Well, I mean, it's a great platform. Slack is like Discord, but Discord is like for gaming. No, I'm kidding.
Jesus Christ, stop.
Opposing counsel is furthering discord. How? I don't know. If the best interests of the children is the goal, why are lawyers allowed to foment discord? Okay, well, tell us, what is he doing to foment discord? Petitioner objects to the court's interpretation of the best interests of the children standard. And then if the court is using the best interest standard, why is our daughter this? Why is our son that? Those aren't legal arguments. I mean, maybe a judge could figure out what you're trying to say, but legal arguments go more like it is not in the best interest of the children to have the children be doing this. If the best interest of the children is the standard, then why is the respondent allowed to financially abuse petitioner by creating a tax lien on the party's joint real estate property due to the respondent's refusal to pay her share of the property taxes? Well, that's a legitimate thing in divorce. If they're getting divorced, then they're going to be dividing their property, and if one party isn't paying their taxes and the property is going to get a tax lien against it, yeah, you would get an attorney, you would go to court, the attorney would fight for the tax lien to be avoided by the proper payment of the taxes. However, we also know that he's not paying his child support, or at least we think maybe he's not paying his child support because he's getting his wages garnished, right? Why would his wages be garnished if he was voluntarily paying his child support? Just saying. Is putting one parent in debt due to the actions of the other parent in the best interests of the children? Oh, this is self-aware wolves right here. Or self-werewolves. He's so close. He's so close. It's him who's not acting in the best interests of the child by putting the other parent in debt. At least that's my guess. That's my guess so far. Petitioner objects to the respondent using these court proceedings as a venue to defame and make false allegations. Yes, but are you saying what those are? Have you hired an attorney to do this for you? Why can't he hire an attorney? Is it because he's really stubborn? Or is it because no attorney would want to deal with somebody who wants them to make these kinds of arguments? Or maybe, hang on, let me put the two together. Would an attorney who's being treated like this charge a small amount of money or a large amount of money? Have you ever heard of the asshole tax? I don't think this guy's ever heard of the asshole tax. Petitioner objects to the respondent's income being calculated at $10 an hour when the respondent's pay stubs show she actually makes $12.25 an hour, and also maintains a Facebook page which states she is a freelance book editor. Okay, that's a great legal... You should make that argument earlier, not in the first page of the third document that we're going through. Also, these arguments should have been made back before you got your wages garnished, like a long time ago when it was being calculated. The guy probably didn't object, this is just my guess, probably didn't object properly to the entry of the custody or child support, well, or maybe both, arrangement.
I will say that you might be giving the other side a little too much credit.
Which side, petitioner or respondent?
The ex-wife side?
The ex-wife. Too much credit?
Yes. We'll see as it goes on.
Okay.
It might be a case where both sides have some unclean hands here.
Both sides might have some unclean hands here. Okay. Petitioner objects to the court ignoring all modern studies that show children's best interests are, in fact, best served by a joint custody arrangement. Okay, that's great. Petitioner objects to the court accepting the respondent's support affidavit from a known drug addict and drug dealer. Okay, yeah, these are correct arguments. These are fine arguments. Petitioner objects to the district court failing to use strict scrutiny. Well, okay, that's not a thing. It's best interest of the child. Strict scrutiny is definitely a thing, but that's going to be whether or not the court has the ability to enforce the best interest of the child standard. And yes, the court has a compelling state interest that is narrowly tailored to affecting the EFF, affecting the best interest of the child. Petitioner objects again to the imputation of income. And as this restricts petitioner's fundamental right to live where he chooses, instead petitioner must live somewhere relatively close in distance to an employer who is likely to employ and able to pay $73,000 per year. So at $73,000 per year, you can expect his child support order is probably several $100s, maybe even $1,000 or more per month. And if she is at $10 an hour, it's probably her child support portion would only be a little bit, a couple $100s a month at the most. And remember, there are 3 children, so that's going to maybe multiply it too. He might be paying more than $1,000 in child support a month. But it sounds like he's not making $73,000 a year. This is an absorb infringement. I think he means absurd. Infringement of freedom and liberty because it precludes petitioner from living in Harlan, Iowa. He has no chance of finding a work in a chosen career field at $73,000. So he says that he doesn't make and can't make anywhere near $73,000. And the court put him in a catch-22 situation, and they called petitioner immature. Since when is that the litmus test for parenting, and what standard do they use to determine this stealth maturity level? Okay, some of this is actually a legal argument. I agree that he should have gotten an attorney, and he should be making these arguments through an attorney. There's also kind of an inherent human bias where you might hire an attorney just because it makes you look good. It makes you look like you're sincere, and the attorney will be the translator between you, who wants to make all these, the ones that are stupid, not all of them are stupid here, but the stupid arguments, especially the whole freaking first one that we read, that's going to piss off the judge. Like, we're what, like 45 minutes into this, and it's kind of turned us off, right? Like, we're here for the schadenfreude of it, not because, oh, we really want to understand what this guy is trying to do here. No, if I was a judge trying to read this, I'd be like, I'm going to lunch. I'm going to put this down. I'm going to write, in red pen over it, like denied or whatever, and then I'm going to go to lunch. And I'm not saying that that's what I would actually do. I'm just saying, like, that's the attitude I expect someone to come at this with. So then, here we go, everybody. I know you've been waiting for it patiently. Motion for trial by combat. I guess if you want to get somebody's attention, you got our attention. Regarding the disputes of illegal telephone and electronic contact, as well as unpaid property taxes, the petitioner demands the court sanction trial by combat to resolve these disputes between petitioner and respondent. Trial by combat was still regarded as a legitimate method for dispute resolution when the Constitution was ratified by the original 13 colonies. To this day, trial by combat has never been explicitly banned or restricted as a right in the United States. Under the Ninth Amendment, any rights not specifically enumerated in the Constitution are still retained by the people. Trial by combat, it was used recently in 1818. I don't think that's very recent.
Recently.
After the U.S. Constitution was ratified, and as recently as 2016, the New York State Supreme Court Justice Philip Minardo noted that the state court did not have the power to sanction trial by combat. Oh wait, did. I imputed a word. Philip G. Minardo noted that the state court did have the power to sanction trial by combat. Thus, I submit this Iowa State Court also has such power to allow the respondent and I to resolve our disputes on the field of battle. The respondent, by and through her counsel of record, have indicated that they have destroyed me legally, and now I wish to give them a chance to meet me on the field of battle where I will rend their souls from their corporeal from our military officer bodies.
Oh
Corporeal.
My God.
In the event the respondent or her counsel file any counter motions or claims, I reserve additional disputes for the field of battle by trial by combat as well. Petitioner requests melee weapons be sanctioned for this trial by combat. The petitioner requests 12 weeks lead time so that he may have one katana and one wakizashi sword forged for use or sourced for use. Okay. Now, of course, this is absolutely ridiculous. Why? It is not in the best interest of the child for one of their parents to be dead. Like that's...
You have to read the wherefore. Trust me.
Okay. Wherefore the petitioner prays the court-sanctioned trial by combat to resolve the above-noted disputes, where the petitioner and respondent may meet on the field of battle, or in the alternate, the respondent may choose a champion, her counsel, her attorney, to stand in her stead. I don't know that law school prepares you for trial by combat. I mean, I definitely feel I'm a stronger person, morally and ethically and mentally. I don't know if I think it made me a weaker person physically.
Are you sure trial by combat wasn't just an elective that you didn't choose?
Trial by combat may have been an elective.
That sounds right.
Yeah. Let's see. Resistance to motion by trial for motion. Resistance to motion for trial by combat. Comes now respondent. Through the undersigned attorney. Now, let's take a look at the quality of this. I don't know what this is going to say yet, but we'll see if the quality of this looks different than the quality of the other things. Although I do see a wall of text here. The petitioner's motion appears on its face to challenge either the undersigned attorney or the respondent to a form of duel. A duel being a mutual combatant agreement with weapons between two people. The petitioner relies on the Ninth Amendment. As the petitioner accurately states in his motion, it provides that rights not specifically enumerated in the Constitution are retained by the people or the states. The petitioner must believe that since trial by combat is not specifically forbidden by the Constitution, it is in his right to insist that the Iowa District Court approve his request to rend their souls from their corporal. And of course they say sick. What does sick mean? It means this or thus, I believe. And that means, that he's reproducing the error and he hasn't made an error himself. Surely petitioner meant corporeal bodies, which Merriam-Webster defines as having or consisting of the physical material body. Although the respondent and potential combatant, the attorney, I love how he refers to himself as the potential combatant, do have souls to be rended, they respectfully request that the court not order this done. We humbly request the court deny this motion, as the potentially life-ending ramifications surely outweigh the severity of petitioner's proposed legal remedy of trying to avoid responsibility for property taxes and to acquire additional telephonic communication. It should be noted that just because the U.S. and Iowa constitutions do not specifically prohibit battling another person with a deadly katana sword, it does prohibit a court sitting in equity from ordering same. The potential combatant and respondent further resist with the following particulars. The Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The United States Supreme Court in Furman v. Georgia, 1972, found capital punishment a violation of the Eighth Amendment, arguing that the clause should reflect evolving standards of decency as public opinion changed. Others found certain practices in capital trials to be unacceptably arbitrary. The result being a majority decision that halted executions in the United States for several years. Though capital punishment is allowed in the United States today, depending upon jurisdiction, it is not allowed in any forum other than a criminal prosecution and sentencing. It most certainly is not allowed in a family law case involving a dispute surrounding property taxes and telephonic communications. And then there's an Iowa law about dueling. Any citizen of the state who may hereafter be engaged, which I don't think they mean to be married. In fact, they mean in a duel, either as a principal or accessory, shall forever be disqualified from holding any office under the Constitution and laws of the state. So there is an Iowa law that prohibits officers from being duelers, or rather duelers from being officers. How about that? We contend that petitioner's motion requests exactly that, a duel. It is possible that respondent or potential combatant may wish to institute their right under the Iowa Constitution to run for public office. Okay, that's a decent argument, that they cannot duel because if they ever ran for public office, they would be then disqualified.
And I think that's to prevent. There was a trend going on for a while back when Iowa was actually being founded in the early 1800s of like vice presidents dueling people because they were like pissed off about them besmirching their honor, you know. So, I think that's to prevent that from happening.
No person shall be deprived of life, liberty, or property without due process of law, which that's the Fifth Amendment. That's the, that's also apparently the Article 1, Section 9 of the Iowa Constitution. It follows that potential combatant and respondent have an enumerated right to life. Surely petitioner's request for the court to order a life possibly be taken without complying with the Fifth Amendment right to due process should be denied. Here's a citation for you, Tack. See every due process ruling ever issued by a court in the United States.
I'm on it. I will have it collected by midnight.
Disqualified persons, no idiot or insane person or person convicted of any infamous crime shall be entitled to the privilege of an elector. The Iowa Constitution clearly prohibits insane persons from voting for elected officials. Currently, the potential combatant and respondent are registered voters and vote frequently, if not always. Neither wishes to endanger their right to vote by participating in deadly combat for such insignificant reasons as property taxes and telephone communication rights stemming from a district court order in a dissolution of marriage case. Surely, were we to engage in trial by combat with melee weapons as petitioner proposes, we would be objectively considered insane by any mental health professional. So there's a roundabout way of calling the petitioner insane, right? As we wish to retain our enumerated rights to vote, we resist petitioner's motion. We therefore pray that the court denies the motion. That's interesting. So then how about the response from petitioner David Ostrom? He admits to misspelling corporeal. He is not suggesting an illegal duel. He is suggesting a legally sanctioned trial by combat. He objects to being called insane. So he got it. He got the message. He figured it out. Petitioner has no record of mental health issues and respondent does. Okay. So he's calling the other person insane now, or at least having mental health issues. He's willing to submit to psychological tests. Trial by combat was decided in favor of the victorious party, though this does not necessarily mean death. The participant can lose by way of death or yielding, which he calls crying craven, or being too disabled to continue. I assert that the respondent and her counsel have chosen to cry craven, and thus have chosen to lose this trial by combat of their own volition. Oh, well, this is fun. Respondent and counsel have proven themselves to be cravens by refusing to answer the call of battle. Thus, they should lose this motion by default. In the alternative, petitioner suggests and agrees to using blunted practice-style katanas and wakizashis. So, I think I've changed my mind, Tack. I think the judge should grant this, have the actual combat in the courtroom, invite the local TV stations, give them some wooden swords to beat on each other with, and maybe call it after about 5 minutes and declare them both insane.
See, at first I was a little bit concerned about David Ostrom, and I was like, oh, is this going in soft sit territory? And like, I don't know. But his response here, I think, really shows that the original trial by combat, like, it's tongue in cheek, and he's kind of miffed that the other side is taking it so
I'm
seriously.
still concerned by all the
and-
natural person and stuff, natural rights, and all the misstatements of law. But okay,
Yeah, but he's turning my opinion of him a little bit more. I'm willing to read more of his stuff now.
and yes, someone correctly points out that the judge hasn't granted the trial by combat, so they can't have lost it by default yet. So then they respond now again. The court should take judicial notice of the motion for trial by combat. That in said motion, the petitioner requested the court sanction the use of melee weapons. He intended to write corporeal body. This is a threat on respondent's life in no uncertain terms. This motion was also subject to a newspaper article. Respondent believes that petitioner's mental state is severely in question. Respondent further requests the court order the petitioner to undergo psychological testing.
Okay, threat on her life? No, I don't think so. I think
Yeah.
he's suggesting that a duel would be appropriate, but I don't think he's actually threatening to kill
Yeah,
her.
and
Now, craziness, probably.
yeah, he's asked the court. Now, we want people to ask the courts for things instead of fighting with each other. If you are having such a fight that you cannot resolve it yourself, we don't want you to go busting people's doors down or hitting people or driving your car over people like my first ex-wife did to me, that third one. And I actually still have the pants with the tire tread on it that I brought to court to prove it. But we want them to use the court. So the fact that he's using the court tells me this is not a threat. So I don't think that's anything at all. Is this filing enough for them to hold a hearing on whether or not petitioner should undergo psychological testing? Maybe there is enough here to at least hold a hearing and then have him say, no, I'm just being tongue-in-cheek, Your Honor. Or maybe he'll come to court and act like a fool, and they will order psychological testing. Either way, I think you see what's going on here is two people don't like each other very much, and so they are trying to make their lives as difficult as possible.
For the next document, I've updated the redactions. So for number 9, you need to
I'm going to
reopen
reload
that.
number 9.
Yeah.
Thanks. You just caught me before I loaded it on the screen. Thank you. All right. So this should be number 9 then. Comes now petitioner David Ostrom. Motion to sanction opposing counsel for misconduct. On October 3rd, Matthew Hudson, opposing counsel, indicated that he destroyed the petitioner in court when the petitioner asked to resolve the issue of being denied telephone and electronic contact. He goes on to say that petitioner should have taken being destroyed as warning enough, implying another threat. Petitioner asked the court to sanction him for misconduct and behavior unbecoming a lawyer. Okay. You might even file a disciplinary action if a disciplinary complaint with the bar, basically the Iowa bar, if you felt like a lawyer had done something unbecoming a lawyer. And then the disciplinary committee explores that and decides whether or not it's worth even forwarding it to the attorney, and then maybe they forward it to the attorney and the attorney has to respond. I don't think telling, somebody, I destroyed you in court is inappropriate. Maybe it's not the best thing to do, but, lawyers are allowed their free speech rights too, and he's not threatening the guy. He's saying, I won in court in the same sense. I owned you. We say that stuff like, oh, you've been owned. I mean, I don't know if kids say that today, but, that was a thing at one time. So saying somebody was destroyed in court, yeah, it's a thing people have said. I don't see how that's terrible. Maybe not quite reaches a level of unbecoming a lawyer, but I wouldn't go around saying that. Other parties do appreciate you being an officer of the court, and you are an officer of the court, so.
Yes, Leonard, kids do still say that.
Okay. Petitioner asked the court to sanction that specifically for engagement in conduct that is prejudicial to the administration of justice. He's now reading the duties of an attorney and judge. Rather than attempt even minimal communications in an effort to resolve the divorce decree, which has, I guess, already been issued, Attorney Hudson threatens the petitioner not only with being destroyed, but with frivolous harassment lawsuits. You can threaten somebody with a lawsuit. There are things you can do about that, like file a lawsuit back or something, but you're allowed to threaten someone with a lawsuit.
In general, it's something lawyers do a lot, is threaten someone with a lawsuit.
I'm going to sue you.
Very hard to be a lawyer if you weren't allowed to threaten someone with a lawsuit.
Attorney Hudson knows petitioner is acting pro se without an attorney and is communicating directly regarding divorce decree disputes, yet Attorney Hudson's response is to bully, threaten, and use the law to intimidate a pro se litigant. Yeah, he's allowed to do that. Now, if he calls them names, okay, we're starting to get into a point where maybe a lawyer shouldn't be calling even an opposing party names, but they are totally allowed to talk to the pro se party because the pro se party does not have an attorney. It is highly unprofessional of a bar lawyer to call pro se litigant names. Yeah, okay, complain to the bar for that one. This is a direct violation of the rules of professional conduct. He's not bound under the American Bar Association rules. He's bound under the Iowa rules of professional conduct if he is an Iowa attorney. He has needlessly multiplied these proceedings, etc. Okay, that's an argument. That's an argument, but again, you need to say how. You need to give more. He's multiplied them rather than communicate fairly towards resolution is not enough. We need to know what. We need to be given the facts. Remember, was it Joe Friday? Just the facts, ma'am. Just the facts. Okay, so now he wants the attorney to be sanctioned for misconduct and personally threatening by saying that he destroyed him in court. I don't think that's a threat.
He has provided the emails below.
Oh, did I miss that?
I suggest that you read them in order that they were sent. But
okay, so like from the bottom up.
Exactly.
Hey, David, I emailed you to stop contacting me. I don't work for you. I will call law enforcement if I receive another email from you. Once again, dipshit. There is no ongoing case or pending litigation. This is your last warning. I destroyed you in court. That should have been warning enough. Any further slander will be litigated also. Oh, David Ostrom said first. Sorry. Calls to your phone. I'm imagining he's dictated that to his phone. That's why it says calls, and he means calls. Calls to your phone to reach the children immediately go to voicemail. You are interfering with my ability to speak to children. There's a court order that says I get reasonable contact with the children. Your phone never rings. I mean, maybe he's got his number blocked. Now, here's the thing, though. If opposing counsel blocks me, that's not going to go well for them, I don't think, if I'm a pro se party. I think an attorney representing the wife has to deal with the opposing pro se party. I've done these where the opposing party was pro se and I was the attorney, and it sucked. But it does not mean that I'm allowed to block them from all communication. If I want to block them from all communication, I would think about going to court and asking for permission to block certain forms of communication and having the judge order what kinds of communication are allowed. That might be appropriate. And then David responds, I'm a pro se litigant. There's an active court order, final decree of divorce, which said I am to receive reasonable electronic and phone conversation with our children. I'm representing myself and you chose to represent the respondent. Your client's phone doesn't even ring when I call to speak to our children. I have this on video and you and your client refuse to address this behavior. Yeah, that should be something that's addressed by the court. If the attorney isn't responding to those requests and he's not getting his court-ordered contact with the children, then yeah, you make a motion for contempt of the court order, of the custody order. Your client refuses to address property tax or theft of property. Yeah, you have to make a motion for that. I asked you and your client for a contact schedule. Where is it? Yeah, these things should be handled by the court. You're also supposed to treat me with as much respect as you would treat any other attorney. And yeah, so calling names is not necessarily in anybody's best interest. So David can talk to the grievance committee or the state bar about filing a disciplinary complaint, some kind of complaint, whatever Iowa bar allows, and then, they'll look into that and decide whether this attorney has behaved improperly or not.
Now, one of the defenses for the lawyer that he has not brought up, but that I was thinking of, is that if he has concluded his representation of the ex-wife, by saying, so I handled the divorce, there's a divorce decree, everything's over,
I no longer represent. Yeah, then he should say that. That's all he has to say is, I'm sorry you feel that way, David. I no longer represent, the party. You'll want to contact their new attorney or whatever. I'm guessing that the ex has blocked him as well, and so that does make things difficult, especially if he has joint legal custody. He's supposed to be able to talk to the ex-wife or the mother of the children and make various arrangements. He's supposed to know what's going on in school and make decisions about the child's schooling and medical problems and treatments and other things. So they make parenting decisions together. This is supposed to be something parents do together in a constructive way. Obviously, there's been a breakdown of that. Normally, you would have the court decide what contact arrangement there should be. He goes on, I've been trying to avoid further litigation by communicating with you about issues that need to be resolved. Your responses are to avoid addressing them. If you would like to have little or no communication from me, then I suggest you have your client follow the court order. Oh, that makes sense. That makes sense. And he apparently has not withdrawn as active counsel. So, hey, that's a pretty sane email right there. I don't know what you think about it, Tack or Brandon.
Yeah, and I think this is why I brought up earlier that maybe both sides have done things to make the situation more tense, to escalate it. But I think it also shows, why this guy might be frustrated enough to submit a joke motion for trial by combat. Yeah.
So then he responds to the request for court-ordered psychological evaluation. Petitioner cannot be punished and held to account for exercising his legal rights to request a court to do something by way of motion. A person is not insane or unfit because they follow the legal process for making a request. If anything, this shows the petitioner is not a threat and that he has taken the matter to court to weigh in on. Yes, that's what I said. Wow, did I just...
That's a good legal argument.
Did I just agree with this guy? Oh my God. If anything, no. However, the respondent and her counsel are using this as a way to deny petitioner time and contact with his children, which has been an ongoing pattern for many months. Petitioner is tired of the respondent getting away with using the court to inflict damage and harm. If he's so tired, why won't he hire an attorney? Respondent is unwilling and unable to foster a relationship between the children and the other parent. Custody should be changed immediately. Well, yeah, there's definitely some kind of violation of the court order if he's not been being given contact with his children, and the court order says so. So then, I think what we have here last then is the court finally responds, right? This is the order. Do we know what judge? Judge Craig Dreismeyer. Now this 13th day of January, just a couple days ago, this court, having had an opportunity to review multiple pleadings, in this case as follows. January 2nd, petitioner's petition for writ of quo warranto. January 2nd, objection support order ruling regarding dismissal violations. January 2nd, objection violation of fundamental natural rights. Second, motion for clarification of telephonic and electronic contact. We didn't go over some of these things because some of these things heavily involve the children. January 3rd, motion for trial by combat. January 10th, resistance to motion for trial by combat. January 10th, motion to suspend visitation and order psychological evaluation. January 10th, response. So these are the resistance. And these are including the resistances. I'll highlight them. This is the respondent's response. This is the respondent's. Oh, that's not the one. This is probably also respondent. Did we read the motion for contempt of final decree of divorce? I don't think so. Either way, response to the resistance, the response to the motion for suspended visitation, the motion to sanction opposing counsel, the motion for contempt, the motion for a guardian ad litem. A guardian ad litem is a lawyer for the child, a separate lawyer for the child that the court has to appoint. And then the court writes, with the exception of the petition for writ of quo warranto, all the other pleadings filed are either in the form of a motion or an objection. Generally speaking, the filing of a motion or an objection will not suffice as a mechanism to initiate an action before this court. To the extent either party believes it has properly brought an action before the court at this time, this court is hereby stating it does not consider anything filed to date as such. The parties are expected to properly initiate these proceedings according to statute or rules of civil procedure as adopted by the state of Iowa. Until these matters are properly brought before the court, no further court action will be taken. As for the motion for contempt of final decree of divorce, the court notes that a contempt matter is an action which could be heard by this court. However, as it is currently filed, petitioner's motion does not conform with Iowa Chapter 665. Hey, why don't we see what he was supposed to do? Let me go look up Iowa Chapter 665. Courts, acts constituting contempt in records of courts, punishment, imprisonment, affidavits, notice to show cause. Before punishing for contempt, unless the offender is already in the presence of court, the offender must be served personally with an order to show cause against the punishment. Okay. And that's it. So what is an order to show cause? It's not a motion. You write out an order to show cause why something shouldn't be granted or why something should be granted. So you ask the court to order a show cause hearing for contempt of the decree. This wouldn't be a problem if he had hired an attorney, because the attorney would have filed the proper form. And depending upon how the state works or whatever, I often had to also then call court administration and get the order to show cause hearing scheduled, so that just to get the order to show cause, I would have to go to a something more than just daily motions court, because maybe the judge wants to hear more about it than just what can be done in a few minutes at 9 o'clock in the morning. As usually they hold motions court at 9 o'clock in the morning, maybe 9 to 9:30 or something. Sometimes it runs overtime, and then the judges break. They, kind of like football players on a football field. They they huddle up, but then they all break and go to their courtrooms, their positions, and then they go play the game. As such, no further action will be taken until petitioner has properly filed all relevant pleadings, which seem to be in order to show cause. I'm not an Iowa attorney, so I'm not going to have any authority. Even if I correctly interpreted that rule, I am not an officer of Iowa courts, so I couldn't tell you as far as legal advice if all he has to do is file an order to show cause. But it seems like he has to do something with an order to show cause. As to respondent's motion to suspend visitation, the court notes that there has been no application to modify, that's a shorthand. Application to modify is modify custody. So that has not been properly filed. And concerning petitioner's petition for writ of quo warranto, this court notes that petitioner fails to reflect how this action fits under Iowa law pursuant to Iowa Rules of Civil Procedure 1-1301 et sequitur, or even that petitioner has taken the appropriate steps to proceed in this fashion as outlined in those rules. Further, there has been no showing of any service of process being completed as well. So that's another thing. you need to include a certificate of service, which literally is just saying, yes, I sent this to the other party, in so many words. I certify that on the following date, I sent this pleading to the opposing party via email, fax, and snail mail to the following address. That kind of thing. Today, I just filed a motion in the Jonathan Wyckoff matter, for example, and I had to put how I served the motion to opposing counsel, and we have the case management electronic case filing system called CMECF, and so I put CC all opposing counsel, or all counsel of record by CMECF. So that's all you have to say something like that so that the court knows that you did it. And so the court then concludes, until the procedural steps taken to initiate a court proceeding are followed, this court will make no further action concerning any motion, objection, or petition filed by either party at this time. So ordered. And there is a footnote. Further, there has been no showing that any party has been appropriately served. So that's the certificate of service that I was talking about. It appears as though perhaps both petitioner and respondent may be submitting to the jurisdiction of this court by filing responses or resistances to something filed by the other. However, as noted, this court does not consider any motion or objection filed as even initiating a cause of action before this court at this time. So what is that going to do, though? By him filing these things in this court, the court should not have to prove jurisdiction to him. He has submitted to or waived his right to avoid jurisdiction of the court because he has filed stuff in the court. He needs an attorney. He really needs his own attorney. I understand that attorneys are expensive, but now do you understand why, if you didn't before, why do you think family law attorneys are expensive? Well, they've got to put up with this stuff, and this stuff is not just this one case. No, this case isn't going to pay for the attorney's life. No, this is one case. The attorney's going to have 20 or 30 of these cases, maybe even more. I bet you there are attorneys out there with way more than 20 or 30 cases. And people are fighting like this all the time in family court. And that really takes a toll on me. Okay, I'll just personalize it. It really took a toll on me. And I had no desire to continue practicing family law after my last family law case, which was one of a similar kind of case where the mother and father had I don't even know if they were ever married. They had a child, and the mother was mistreating the child. What was it called? Malingering by proxy. She would rile the child up before the child had to go to school, or before the child and the mother went into the Social Security office, and then she would rile the child up, get the child all upset and everything, and then walk into the school and go, look what I have to deal with. And so the child was treated as though she had a mental impairment, and the child was, had a developmental delay because of all of that. And we went to court and showed that all of that was caused by the mother, got the child the help that she needed, and the child has now caught up with her peers and made honor roll. And I believe she's turning 18 sometime here. So, and I have permission to talk about all of that, and I'm not going to go into any further detail, but, that sort of thing takes its toll on you psychologically. And if you're not getting paid for that, that also takes its toll on you psychologically, because you don't have anything to do about it. You can't go home and buy yourself a nice steak or make a payment on a nice car, or something to comfort yourself, or literally pay for your doctor copay for having to see your own psychologist or whatever, for having to deal with people who are fighting. The people who need lawyers, it does take two. It does take two to dance, and it doesn't mean that any one party is always the perpetrator of nastiness. But it only takes one party to be really nasty to the other, and something has to go into court. And a lot of times in a divorce, both parties, now I'm just speaking generally, both parties are more interested in fighting with each other and destroying each other, to use the language from this case, than they are in actually resolving the divorce and marriage and all that, and the custody arrangement in a mutually agreeable, amicable way. Many people can resolve those things. Yours truly has been divorced twice and didn't need to involve lawyers for more than the divorce. I'm not going to go into the further what happened with my first ex-wife running me over with a car, but there was further court action about that. But that doesn't need to be talked about right now. That's very personal. But the otherwise, the divorces were amicably resolved, and I didn't need lawyers other than just to file the paperwork. No one actually had to go to court. We just had to file the paperwork to get the divorces done. It wasn't a big deal. People who need lawyers to fight in court over divorces are like that famous couple who had divided their Beanie Babies in court. Let me see if I can bring up this one, the Beanie Baby divorce. We'll just show you the picture. Hey.
Sorry, that was an accident.
So
Did not mean
here's
to talk in Discord.
That's okay. So here's the Beanie Baby divorce. This is an actual picture from a 1999 divorcing couple who couldn't divide their Beanie Babies. So what they did was they ended up having to divide their Beanie Babies among themselves in the courtroom. While you can see some lawyer back there in the corner is like, I went to law school for this. At least maybe the lawyer's getting paid. So this is the most expensive separation of Beanie Babies that anybody has ever seen, I think. Maybe somebody come up with a better one, but this is the most expensive separation of Beanie Babies that I've ever seen. And then there was a thread on Reddit a little while ago where someone was telling don't get divorced this way, that their parents or some relatives or somebody that they knew about had made them, they had raised $1 million throughout their marriage, and they were going to be splitting the $1 million halfway. So $500,000 to each of them, except that they were very upset at each other for not fulfilling, a lifelong commitment of marriage. I don't even know what the circumstances were, but they were so upset with one another that they hired attorneys to basically spend all their money on attorneys instead. And they ended up going through about $300,000 or more each, leaving $1 million estate reduced to $400,000 or less to be split among them. And so now, instead of retiring on $500,000 apiece, they were retiring on $200,000 apiece, which is not going to be enough to sustain you in retirement.
Just to provide a little bit of closure for our story, there is an order that we don't have to look at because it's just all very judge language. But there's an order for mediation and parenting classes. And so that's one of the last things that's filed in this case. So they are being sent to mediation, so they do get to talk it out. Yeah,
so they'll talk it out with a mediator, and I can reveal that the mediator will be very compelling. The mediator will be explaining, look, your next step is to go before a judge who already hates you. So you'd better work it out with the mediator, because if you don't, you're going to get a judge that doesn't want to see either of you people. And then I thought we would also recommend a book about dueling. If you would like to support our channel, you can use our Amazon affiliates link that Brandon will post in the description and in the chat. If you could do that now, Brandon. This is The Last Duel, a true story of crime, scandal, and trial by combat. This was recommended to me by another attorney in the lawyers subreddit on Reddit, which is a private subreddit only accessible to licensed attorneys who are verified through the moderator. It is a gripping story true to the duel, or a gripping true story of the duel to end all duels in medieval France that pits a knight against a squire accused of violating the knight's beautiful young wife, which is soon to be a motion picture. It's only $8.37 on Kindle and $11.74 on paperback. We could not find it on Audible. You can also help our channel by subscribing to Audible through the Audible subscription Audible trial link that's in our description. Uncivil law. Kurt, hi, says, I challenge Leonard to trial by combat. How about I challenge you to an airsoft trial by combat? I'd be willing to do that. I have some airsoft equipment. I have face masks, and I
have a big backyard you can use.
I have a big backyard, and you can have the automatic. I'll take the bolt action sniper rifle, and we'll start from 300 feet away and see if you even get to me.
Dude, your backyard is perfect for an airsoft duel.
Except
your house.
Well, yeah. See, except that Allentown bans air guns, and I looked up the Allentown regulation, and although I could probably get away with it, just speaking legally here, the air gun law in Allentown doesn't make any distinction between airsoft and pellet guns and stuff. And
also, the sound of those firing is going to sound a bit like gunfire.
No, not really. They just go like is all they do. It doesn't at all sound like a gun.
Okay.
It will sound a little bit like an air gun, I guess. And you would never. Here's the other thing. I'm in a city with dense people, dense population and all that. Police officers are not going to respond to air guns assuming that they're air guns. They're going to assume that they're real guns, and people, and this happens regularly, people get shot by police because the police really thought that the air gun was a real gun. Kids especially love to play with guns, right? So sure, a kid might somehow, maybe even with the parents' permission, get a hold of a pellet gun or a BB gun or something and plink with that in their backyard, I used to do that. I used to set up a whole target thing where I had like a little air gun thing, the resettable target where you hit it 5 times and then the 6th time it resets and you can hit it again. I used to love to practice my sniper rifle, shots with a Gammo 1200 feet per second break barrel air gun and a 12x scope, and I used to set up candles in a row and shoot the flames, or try to shoot the flames out of the candles, and I did. I got to the point where I could shoot the flames out of the candles without destroying the candle, and you go light them up, you go light the candles again, you go back and you shoot the flames out of the candles. It's really fun to do that. It's also giving a child a gun. So if a police officer had showed up and said, "We heard about somebody with a rifle in your backyard, stick them up," suddenly, a child has a gun or something that looks very much like a gun, and no, that air gun did not have like a orange tip on it or anything. So yeah, don't do that. Do your airsoft in a place where it is either sanctioned or legal, or someplace where you're pretty sure a police officer is not going to show up and shoot you.
Okay, quick story time. I know that you're probably trying to end the stream.
I'm fine, go ahead.
But when my husband and I were moving to a new apartment, we were reading through the lease, and it said, that we couldn't have firearms. But my husband's a big nerd, and he war history buff, and so he had a musket. And I was like, okay, well, does the musket count as a firearm? We're wondering what to do, and we asked the landlord, and the landlord was like, it's a musket should be fine, but maybe if you have another place to store it though. And he explained that earlier in the year he had to enter an apartment because it was flooding, and it was causing flooding for all the apartments below it, so they had to go in and fix it. And they went in, and there was almost like a shrine, and there were these really crazy looking guns on it, like rifles. And it was, they went and they picked them up, and they're like, that's heavy. And so they called the police because, they didn't know if they were legal guns or not. They didn't know what to do. So the police came and looked at them, and they're like, these are paintball guns. And it's fine. But
That's funny.
The landlord didn't know because he just
and maybe that works in Canada, but if you ever did something like that in the United States, you might want to contact an attorney first, because if you find yourself in possession of a gun and you don't know what it is, the police don't always have the most sympathy for people being in possession of guns, even if they've called the police to report the guns. So maybe don't take possession of the guns or contact your attorney first. Meanwhile, Overlapping Magisteria has donated $5 Canadian and says that it is legal to duel in Canada. What I think the difference is that it is not legal to cause bodily harm intentionally. But that doesn't mean that you can't have a fight as long as you don't cause whatever Canada considers bodily harm intentionally. So to me, yeah, you could probably duel like in a non-lethal duel with foils or wooden katanas or something, as long as you're not, breaking arms and causing internal bleeding. I don't know, maybe is bruising considered intentionally bodily harm? I don't think so. But maybe.
The standard that I'm aware of is that the harm has to be greater than something that is transient. So if like bruising would just be
a permanent kind of thing.
Yeah,
or a more than temporary thing. Like, so a broken arm would probably be not necessarily permanent, but it's also not temporary. Like,
yeah, so there's a that would be like a disabling factor. And I think that the dueling laws, the laws that I'm aware of have to do with fighting in sports. That if you are playing a contact sport, there is a certain level of violence that is allowed.
You guys have hockey, right? Yeah.
Oh yeah, like hockey fights. Like if two hockey players get into a fist fight on the ice, they're not criminally responsible for assault.
Okay, but what about like if they knock somebody's teeth out? That's going to be bodily injury, right? Bodily harm. That's permanent. That's permanent.
Is it on purpose that they wanted to disfigure the person?
Okay. So you're saying that the bodily harm being intentional means that they have to intend the bodily harm, not just intend the act that caused the bodily harm. There's a distinction there. So if I'm swinging swords at you, let's say they're real swords, but we're just like clanking the swords together, do I have the intention to cause bodily harm? No. But when I stab you with the sword, then I intended bodily harm.
Yeah, so I know hockey fighting generally doesn't result in criminal stuff. There are exceptions for if you do something like really out of the ordinary. So I think that there was a check that was done to a hockey player and he lost his vision from it. That there was an issue where I think it was a high stick and it got up and it ruined his vision and he couldn't be a hockey player anymore. Mm-hmm. And so the person who did that did have consequences outside of hockey for doing that. But in general, if you're in a contact sport, those injuries are kind of accepted when you get into those types of fights.
Okay.
It's also why, like, if you were to have like MMA fighting, that, black eyes probably wouldn't be that's cause for a criminal thing.
Yeah. All right. So that's our show, everybody. Thank you for joining me on this wonderful Thursday afternoon, evening. Let me play our little thing here.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Because I forgot to apply the right transform, now I do this. So thank you to our $50 plus supporters in the month of January. Thank you to Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Jan Negrey, Spirit Bear, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Stephen, Cute Grills in your area, and Ottah. And we'll have the rest of the $5 plus supporters in the description below. Thank you very much for all of your support. I love you all. I'll see you in whatever video we do for tomorrow. I'm Leonard French, your favorite copyright attorney. Thank you to Tactical and Brandon for their support tonight. Really appreciate you guys. Have a good one. Bye. And wait, I shouldn't end the stream yet. I should do like a face or something so that you can end the stream then, right, Brandon? So when after I say bye, you can click the end of stream button. Brandon? Uh-oh. Did we lose Brandon?
Brandon is both muted and deafened.
Oh, I need to be able to hear him. I will try to find the video before that happens.
Sorry. Hello?
Yep, hang on.
Can you hear me?
I'm gonna take the stream out because I don't think you heard any of my instructions.
I didn't know.
Oh, I need to be able to hear him.